I'm buying on.
Can anybody hear me?
Yes, ma'am, we can hear you. You need to mute
Yes.
yourself.
Okay, perfect. Thank you so much.
Mhm.
Good afternoon, everyone. I hope you all are doing well this afternoon. We'll get started as soon as the jail is ready to go.
Thank you, Your Honor. Do we need to enter our appearance?
Good afternoon, Ms. Steele. Who are you here representing today?
I believe Francis Spalding should be on your misdemeanor first appearance. It was a Saturday arrest at approximately or in the afternoon.
Yes, Judge, position number
Yes, that's
20.
position number 20. So we'll be with you directly, ma'am. Thank you.
Okay,
And
do you
yes,
need
you
a written entry of appearance?
Yes, ma'am.
Yes, we will at some point, but yes, if you can
Okay.
go ahead and get that to the court, we'd appreciate it.
Ms. Lewis, do you want to send me a chat regarding the manner in which it should be done, and I'll send it out?
I sure will.
Thank you so much.
Mhm.
Ms. Lewis, can you tell me the SAP reset date, please?
Yes, Judge, that's going to be June the 20th.
Thank you.
Mhm.
Good afternoon, Judge. How you doing, sir?
I'm doing well. How are you doing this afternoon, Norris?
I'm doing wonderful.
Glad to hear it.
Yes, sir.
Where we-
I'm gonna have position 4, Ms. Cobbs, come up first.
Okay.
Let me see there, Ms. Cobbs.
Yes, good afternoon, Ms. Cobb. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, good afternoon.
Good afternoon, ma'am. You've been charged in case 23 CR 003581G with simple battery family violence. Who do we have on from pretrial this afternoon?
Good afternoon, Judge.
Good afternoon, Ms. Jackson. Good to see you. Does Ms. Cobb have a history?
She has 4 cycles. The last arrest was January the 9th, 2023 for battery, and that was in East Point, Georgia. The defendant does appear to have an open case pending in Clayton County for simple assault. There were no convictions listed in the GCIC, Honor. Nothing in addition.
Thank you. Ms. Falk, good afternoon.
Good afternoon, Your Honor. How are you?
I'm doing well, thank you.
I just want to point out that the defendant is currently on an open bench warrant here in Fulton County under 23 CR 000174G. She was given a $2,000 surety bond by Judge Mincy on January 11th, 2023, with a no further contact with Tyshawn Peters. Stay away from 3255 Chestnut Drive, but there was a one-time escort to verify occupancy and a third-party transfer of their child. This incident happened at 3255 Chestnut Drive on June 2nd of 2023 at around 10:43 p.m. Miss LaRonda Cobb, who is the mother of the defendant, stated that they were in an argument, verbal argument. During the argument, the defendant struck her in the face and pulled her hair. the defendant claimed her mom got in her face and was spitting during the altercation while they were arguing, and she shoved her away. As I stated, the defendant has a bench warrant currently open, as well as a Clayton County simple assault currently open. There is a pattern developing here for violence, especially in the nature of family violence. And we are, to that end, asking for a $3,000 surety bond, stay away from 3255 Chestnut Drive, no further violent contact with LaRonda Cobb, no alcohol, drugs, or weapons. We did have a conversation with Miss LaRonda Cobb, who stated that the defendant's son stopped up the toilet and it was going to cost $300 to get it fixed. That's what started the argument between the two of them. And then it turned physical when the defendant swung at her. She stated the defendant pulled out some of her hair. And she stated she is okay with having contact, but the defendant is no longer allowed to stay at the residence. She stated she will also need to return to collect her belongings and her child. That's all.
Thank you. Good afternoon, Ms. Wills.
Good afternoon, Judge.
Oh, Your Honor, I'm so sorry, PD Wills. Excuse me for interrupting. We also would like to sound for the victim, Miss LaRonda Cobb, Your Honor.
If Ms. Cobb is on the line and wishes to address the court, now is your opportunity to do so. Does not appear so, Ms. Falk. Ms. Wills.
Thank you, Judge. Ms. Cobb is just 20 years old. She is a native of Atlanta. She is currently a student at Health and Styles Institute, where she is studying to become an esthetician. She will qualify to receive our services. She does have a high school diploma from Banneker High School. She is the mother of a 1-year-old child. My client does deny the allegations as alleged. She states that it was her mother who attacked her. She did respond in self-defense, but she also received injuries such as scratches as a result of the attack. And it was her 16-year-old sister who called law enforcement. My client does not desire to return back to that property or to that residence, and states she will move in with her grandmother and update her address once she has that address upon her release. I would like to request a one-time law enforcement escort so that she can pick up her belongings. In regards to the Clayton County case, my client states that that is an old case between her and former friends of hers that she thought possibly was going to be dismissed. I would ask in this case that my client be granted a signature bond. And if Your Honor is not so inclined, I would ask for a $1,000 surety bond.
Sure. No. Attack with Ms. Cobb. Stay away from the Chestnut Drive address. She can go back to that address on one occasion with law enforcement to retrieve any belongings that she might have there. No drugs, alcohol, or weapons while out on bond. Good
Your
luck,
Honor,
Ms. Cobb.
You
Yes, Ms.
broke
Falk.
up during the bond amount, so I was unable to hear that part.
A $3,000 surety bond with all the other conditions that you requested, Ms. Falk.
Yes, Your Honor.
Position number 5 in courtroom number 3.
Okay. Good afternoon, Ms. DeLeon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes. You're
Thank you. You've been charged in case 23 CR 003580H with criminal trespass and giving false information to law enforcement. Is there a history, Ms. Jackson?
The defendant does not have any prior arrests on file, Your Honor. The defendant appeared to meet the criteria for a UJR through the jail.
Ms. Falk?
Yes, Your Honor. This incident happened at the Lost Dog Tavern at 3182 Roswell Road in Atlanta, Georgia on June 3rd of 2023. While the officer, basically a security officer who is a off-duty police officer, while he was at the rear of the establishment, he observed Ms. DeLeon and 2 of her friends walk down the stairs. They were able to, they got into a fight and had to leave the property. They the officer observed the defendant getting into the face of one of the staff members, recording him shouting obscenity, stating she wasn't going to leave after being asked multiple times to leave. A security guard then physically removed the defendant, but she returned, blocking the entrance for the other guests, and continued screaming, was behaving very disorderly. So the defendant, after being told multiple times to leave and refusing to leave, was taken into custody. Once the defendant was placed, the defendant gave her date of birth as March 11th, 2003, and refused to give her name to the officer or any identifying information. That date of birth turned out to be false. Her date of birth is December 1st of 2003. And we did NOD the final charge of interference with government property, but just to let the court know, while she was in the vehicle being transported, she was spitting, kicking, just behaving in a disorderly way inside the vehicle. The state's recommendation on this case is a $4,000 pretrial services bond, $2,000 on count 1, $2,000 on count 2. Stay away from the Lost Dog Tavern at 3182 Roswell Road. No alcohol, drugs, or weapons. And we don't need a no further contact on this one, Your Honor.
Ms. Wells?
I would have no objection to the signature bond. I would ask that it go through the jail as was recommended through pretrial services. My client is 19. This is her first arrest, as it was stated. She is currently a student at Georgia State University, where she'll be entering into her sophomore year. She denies the allegations as alleged, Your Honor.
Okay, it'll be a $4,000, $2,000 for each count, signature bond through the jail. Stay away from the Lost Dog Tavern, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. DeLeon.
Thank you, Your Honor. I'm sorry, what's the bond amount again, Judge? I'm sorry.
It's $2,000 per charge, so a $4,000 signature bond through the jail.
Okay, thank you. But she had, it's 3 charges on her booking.
Right, the state filed an NOD on count 3, which was the interference with government property, and it was filed through the jail, and Mr. Wilburn should have that.
Okay, thank you so much.
Thank you.
Judge, next we have position 25, Ms. Williams.
Good afternoon, I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video? Good afternoon, thank you. You've been charged in case 23 CR 003570A with battery family violence. Is there a history, Ms. Jackson?
She has one prior cycle. That was October the 14th, 2020 in Gwinnett County for theft by shoplifting. There was no disposition for that arrest. Nothing in addition, Your Honor.
Okay. Yes, good afternoon, Ms. Bickerstaff.
Good afternoon, Judge. This incident occurred yesterday at 11046 Alpharetta Highway. And this is where Mr. Indy Livingston advised officers that the defendant struck him multiple times in the face while he was sleeping. Officers noted that Mr. Livingston, his left eye was slightly swollen and it was red and watery. And the defendant told officers that she was confronting Mr. Livingston about cheating on her. And so she did admit to making physical contact to wake him up, and she showed officers how she slapped Mr. Livingston when she woke him up. The defendant and Mr. Livingston do live together. Our office was not able to contact Mr. Livingston today. However, the state's recommendation is a $3,000 surety bond, 1-day anger awareness course, no further contact with Mr. Indy, that's spelled E-N-D-E-E Livingston, and to stay away from 11046 Alpharetta Highway, as well as no alcohol, drugs, or weapons. And I don't believe Mr. Livingston is on the Zoom call, but I would still like to sound for him.
Mr. Livingston is with us. Now is your opportunity to address the court if you choose to do so. Doesn't appear so, Ms. Bickerstaff. Good afternoon, Ms. Kim.
Yes, good afternoon, Your Honor. Mr. Williams is 25 years old and he was born in here in Georgia. Your Honor, he is qualified actually. I mean, she is qualified for public defender services since her small business that she was operating is not doing well. She has been unemployed for about 2 years and tried to build up her business, but it is not working well. Your Honor, she graduated from high school and right now she is financially challenged. On that day, Your Honor, it was Mr. Andy who was drunken and he was kind of high from the drug. Even the police could see 4 or 5 different bottles around him, but apparently my client, who was the one who was upset, and yet she did not strike the complaining witness. It was more about like to wake up, gentle touch. I mean, even though it is physical contact, it is not violent nature. This is her first violent offense ever that she's getting. We would like to request for a signature on bond so that way she can move forward. She has no objection to stay away and no further contact with Mr. Livingston. Thank you.
It's going to be a $3,000 signature bond through pretrial per the judge. 1-day anger awareness, no further contact with Mr. Livingston, stay away from the Alpharetta Highway address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Williams.
Thank you.
Position number 1, Judge.
Good afternoon, Ms. Bailey. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Bailey, you've been charged in case 23 CR 003584J with simple battery family violence. Is there a history, Ms. Jackson?
Yes, she has 2 cycles. The defendant's last arrest was November the 26th, 2015. Out of Columbia County, Georgia, for simple battery, family violence, and criminal trespassing. And she does have 2 misdemeanors. One is a conviction and one is a sentence. That was one in 2016 out of Columbia County for criminal trespassing and battery. And there was one in 2013 where she received a nolo contendere sentence out of Richmond County, Georgia, for simple battery and disorderly conduct. Nothing in addition, Your Honor.
Thank you. Ms. Falk?
Your Honor, just to let the court know, this is a cross warrant with position number 17, Curtis Proctor.
Okay, thank you.
Not a problem. So in the case of Miss Bailey and Mr. Proctor, this happened June 3rd, 2023 at 940 Piedmont Avenue in Atlanta, Georgia at 10:30 p.m. Defendant Proctor flagged down police officers and stated that he and Defendant Bailey, his ex-girlfriend that he lives with, were in a verbal argument. Defendant Bailey picked up Defendant Proctor from work. They went to an Airbnb where they live with their child. An argument ensued. Defendant Proctor stated that he tried to leave, but Defendant Bailey tried to block him from leaving and slapped him in the face in the presence of their child. That would be KP. Defendant Proctor showed officers a cell phone recording of Defendant Bailey following him outside and appearing to make contact with him. Defendant Bailey was then interviewed. She had a bloody nose. She stated they were arguing about accusations of Defendant Bailey being unfaithful. Defendant Proctor slapped her in the face when they returned back to the Airbnb. Defendant Bailey stated she went outside and Defendant Proctor came outside with his things and their child, and that she was not following or harassing him. And then once Defendant Proctor left, Defendant Bailey said she went inside with their child and observed her nose was bleeding. Now, the important thing to note here is both of these defendants have been previously, one has been previously convicted of domestic violence. That is Defendant Bailey. She has a 2016 conviction for family violence battery involving Charles McQueen, so a different victim. Defendant Proctor has multiple open cases involving Defendant Bailey. In fact, we were able to, just got off the phone with Cobb County State Court. He has 3 cases, 23M1234, 23M1235, 23M1237, all with a no further contact with Jasmine Bailey. He also has an open aggravated assault, family violence, battery in Columbia County that involves a person by the name of Jasmine, but it had a different last name. Although defendant Bailey at the scene, when talking to police, stated she was a victim in Richmond County of a strangulation, which Richmond County and Columbia County are part and parcel of the same. I believe they're connected in judicial circuits. So I'm not sure if that is her, but I can conclusively established there's a no further contact with Miss Jasmine Bailey out of Cobb County. When questioned, defendant Bailey admitted she had a TPO as well against defendant Proctor, but had willingly violated it in order to live with him. Clearly, Your Honor, at this point, this is a very toxic and dangerous situation for both of them. There is a TPO that's being violated here. There are no further contact orders being violated here. And clearly the police are continuing to be called. We have approximately 4 cases open within the last 4 years because 3 years, because the aggravated assault out of Columbia County was in 2020. For that reason, on the defendant Jasmine Bailey, we are asking for a $3,000 surety bond, stay away from 940 Piedmont Avenue, that she have a one-time law enforcement escort for belongings. That is an Airbnb, so it is not, she does not own that residence. No further contact with defendant Proctor. We would also note that their child, KO, is currently with Miss Joyce Scott, who's defendant Bailey's mother. And when Your Honor is, I don't know if Your Honor would like me to just segue into the recommendation for defendant Proctor or just wait.
Is this Mr. Proctor in courtroom 2 before me?
Yes,
Yes,
sir.
it is, Judge.
Yes, thank you. I appreciate it. Good afternoon, Mr. Proctor. I'm Judge Eric Morrow. Good afternoon, sir. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, I do.
Thank you. Mr. Proctor, you've been charged in case 23 CR 003583J with simple battery family violence. Let me just go ahead on and get the, Ms. Jackson, do you have anything to add to the history that was given by Ms. Falk?
He has 8 cycles. The last arrest was February the 20th, 2023 in Kennesaw, Georgia, for the violation of a family violence order. He does, that case appear to be still open and pending. He appears to have an open case pending in Richmond County for cruelty to children, 4 counts. And he does have one pending for a DUI, an obstruction of an officer and acquiring a license plate for purpose of concealing identification of a motor vehicle. And also there's another one pending for simple battery, 2 counts, and criminal trespassing. Count 1 misdemeanor conviction that was in Rockdale County in 2017 for a DUI. Nothing in addition, Your Honor.
And yes, Ms. Falk, can you go ahead with the recommendation, please?
Your Honor, our recommendation for defendant Proctor, based on the fact that he has violated a no further contact order, actually 3 no further contact orders involving Jasmine Bailey, and also has an open violation of family violence order, which I would hazard a guess it probably involves Miss Bailey as well. The state's recommendation is a $10,000 surety bond for Mr. Proctor. Same conditions, stay away from 940 Piedmont Avenue in Atlanta, one-time law enforcement escort for belongings, no alcohol, drugs, or weapons, and no further contact with Miss Jasmine Bailey.
Who's representing Miss Bailey?
I am, Your Honor.
You can proceed, Ms. Wills.
Thank you. Miss Bailey is 31 years old. She is a Georgia native. She is currently employed by Wellstar as an LPN. She has worked there for the past 9 months. She has 5 children, and she will qualify to be represented by the Public Defender's Office. She has obtained an associate's degree from Georgia Military College. My client does deny the allegations as alleged. She is scared that Mr. Proctor will kill her one day if they do not stay away from one another. She does not desire to have any further contact with him. And she states that Mr. Proctor called the police because he is always the one who is violent toward her, and made a point to call the police because he wanted to get her in trouble. My client her last arrest was 2015. She does not have a significant criminal history. I would ask that my client be given a signature on bond. If Your Honor is not so inclined, I would ask for a $750 surety bond. I would also ask for a third-party transfer of the child that she shares with Mr. Proctor. My client also indicated that she has some belongings in a shared storage unit with Mr. Proctor. So I would ask for either a third party to pick up those belongings or law enforcement escort because he only has the key to that unit. And that will be all, Your Honor.
Mr. Proctor.
Good afternoon, Your Honor. Mr. Proctor is 35 years old. He is a native of Georgia. He has 2 children. He has a 15-year-old, and he also has a 1-year-old that he shares with the cross defendant, Your Honor. He has legitimated this child, so he is the legal father of the child. We would also, we do not object to the third-party transfer of that child, Your Honor. My client denies that he was the principal aggressor in this case. In fact, it tells me that the cross-defendant was the one who attacked him, and that it was based on the fact that the police officer saw on the video that he had that she was the aggressor and she was attacking him, that she was arrested, Your Honor. He said he was merely defending himself when she attacked him. I know that the state has asked for $10,000 good bond for my client, Your Honor, but I think that that is excessive given the facts and circumstances. I do understand that he does have open cases, so I would ask the court to give my client a much more reasonable bond so he can get out of jail and get back to his job. He is gainfully employed, he tells me, as a manager in retail, Your Honor, and we have no objection to the staying away from the cross defendant. Nothing further, Your Honor.
So for Ms. Bailey, it's going to be a $2,000 surety bond. Stay away from the Piedmont Avenue address. No further contact with Mr. Proctor. Third-party transfer of any minor children, and no drugs, alcohol, or weapons while out on bond. For Mr. Proctor, it's going to be a $5,000 surety. Stay away from the Piedmont Avenue address. Third-party transfer for any minor children, no drugs, alcohol, or weapons while out on bond. Ms. Wills, your client is going to have to work with a third party to retrieve any belongings that she might have in a storage unit somewhere. For both Ms. Bailey and Mr. Proctor, excuse me, let me be very clear what no contact means. No contact means absolutely no contact. No phone contact, no internet contact, of course, no physical contact, no contact whatsoever. If you need to communicate regarding your minor child, it has to be through a third party, but the two of you are to have no contact with each other until these matters are resolved. Good luck to you both.
Can I ask a question?
Your Honor, may this be his one request?
Let me address Mr. Proctor first. Sir, you have a right to remain silent. Anything you say can be used against you. I suggest that if you have a question that you speak with Ms. McLeod after court today so that she can clarify whatever your question is, but I don't want you to put yourself in any jeopardy by speaking, okay?
No, it's not that.
Is that related to your bond, Mr. Proctor?
It's in relation to the child that we share. I totally agree with the third party transfer, but I asked, I'll speak with Ms. McQueen afterwards. I just wanted to, I don't have anybody else's phone number that she resides with, so I don't have a way of, I guess what I'm trying to say.
I believe we spoke about that, Mr. Proctor. Your mom can contact her.
Oh, perfect. Thank you so much.
You're welcome.
Yes, Ms. Falk.
In your honor, I apologize for interrupting the court and defendant Proctor. I would just like to add that we are requesting a one-time law enforcement escort for the belongings at the Piedmont Avenue address, since they are both having to go there to get their items out. I think a one-time law enforcement escort is necessary to make sure they don't interact with each other.
That is
Okay.
correct, Your Honor. It's an Airbnb. It's not where they live, but they
Okay,
do
so
there.
each of them can have a one-time escort with law enforcement to retrieve any belongings that might be at the 940 Piedmont Avenue address. All right, good luck to you both.
Thank you so
Who do we
much.
have next? You're welcome.
Position 14. Yeah. Okay.
Good afternoon, Ms. McQuilla. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. You need to have your case heard by video.
Yes.
Thank you. You've been charged in case 23 CR 003590J with battery family violence. Is there a history? Ms. Jackson?
Yes, Your Honor, the defendant does not have any prior arrests on file. Nothing in addition.
Bickerstaff?
Yes, Your Honor. So this incident occurred 4/16/2023 at 4900 Delano Road, apartment 7E. And this is where the defendant attempted to stab Mr. Kenai Lopez. That's spelled Kenai. This is where the defendant attempted to stab Mr. Lopez with a screwdriver during an argument they were having. Officers discovered a small laceration to Mr. Lopez's upper back, but the officer did note in the police report that it was unknown whether the laceration on his back was of a pattern consistent with the mark that a screwdriver could leave, Your Honor. Our office was not able to get in contact with Mr. Lopez today, but however, the state's recommendation is a $10,000 surety bond, 1-day anger awareness course, no further contact with Mr. Lopez, and to stay away from, I believe the defendant and Mr. Lopez, they live together at 5007 Lower Elm Street, but the incident happened at the Delano residence. But I would ask for a stay away at the residence that they share together, which is the Elm Street address. And I don't believe Mr. Lopez is on the Zoom call, but I would still like to sound for him.
Mr. Lopez is with us this afternoon. Now is your opportunity to address the court if you choose to do so. Doesn't appear so, Ms. Bickerstaff. Ms. McLeod?
Yes, Your Honor. My client is 18 years old. She is a high school graduate. She is gainfully employed as a server at the Fridays at the airport, she tells me, Your Honor. She and the alleged victim share a 7-month-old child. They do not live together. This incident, the address where the incident is alleged to have happened is my client's address. She does not live with Mr. Lopez, and this is not his home at all. This is where she resides with her child. I would ask the court, given the fact that my client has never been arrested, to give her a signature bond so she can get out of jail, go back to taking care of her child and to her job. She is okay with an order which says a third-party transfer of the child, because they do share a child, and she has said to me that she doesn't want to keep him away from his child, even though the child has not been legitimated. So she's okay with third-party transfer of the child, and he should stay away from her residence. Nothing further, Your Honor.
So she lives at the Delano Drive
Yes,
address,
Your
Ms.
Honor.
McLeod?
That is her address where she lives with her child.
Okay.
He doesn't live.
It's
gonna be
unclear whether it might be, Your Honor, Mr. Lopez might live at the Elm Street address. And if he does live at the Elm Street address, I'll still ask for a stay away from his address. That address was also listed in the police warrant.
Your Honor,
Well-
my client is okay with staying away from where he lives. And she also tells me that they are not in a relationship anymore. They are co-parenting. They're not in a relationship because he attacked her. He has an open case in Fulton County for attacking my client. So she has no interest in going to where he lives, but this is her apartment that she lives with her child.
It's going to be a $5,000 signature bond through pretrial per the judge, 1 day anger awareness, no further contact with Mr. Lopez, stay away from Mr. Lopez's address on Elm Street, third party transfer of any minor children. Does she live, Ms. McLeod, at the Delando address with anyone?
Just with her child, Your Honor. She lives with her child and no one else.
Ms. Jackson is at 18. Is she going to need a cosigner?
Yes, Your Honor.
Okay. Is there anybody that can cosign for her, Ms. McLeod?
Perhaps her mom, Your Honor, may be able to do so. I'm going to have to get that contact because I thought that since she was an adult, she had a child of her own, that she would be able to do her own signing.
Well, if I send her through pretrial, then
I stay by myself. I don't have anybody to come sign me out. It's just me and my baby.
all right. I am going to, instead of sending her through pretrial, I'm going to send her through the jail. And given the circumstances, I'm not going to require the 1 day anger awareness, but no further contact and third party transfer.
Thank you, Your Honor.
All right. Good luck to you, Ms. McQuillan.
Your Honor, that concludes my business before the court today. May I be excused?
Yes. Thank you, Ms. McLeod. We appreciate it. Courtroom 3, do you have Francis Spalding there?
Yes, Judge. Would you like to do that case name?
We have a private attorney on the line, Ms.
Okay,
Steele.
I didn't know. I'm sorry.
That's fine.
Yeah, we go to position number 20.
Good afternoon, Ms. Spalding. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Ms. Spalding, you've been charged in case 23 CR 0035688H with driving under the influence of alcohol 0.08 grams or more and driving under the influence of alcohol less safe. Is there a history, Ms. Jackson?
The defendant does not have any prior arrests on file. The defendant appeared to meet the criteria for UJR through the jail. Nothing in addition, Your Honor.
Ms. Bickerstaff?
Yes, so Your Honor, this incident happened on June the 3rd. And this is where, and it happened at the Roswell Police Department at 39 Hill Street. And officers arrived there in response to a car accident involving the defendant where she struck the police department's rear entry gates with her car. When officers opened the defendant's car door, they noted that they immediately smelled alcohol coming from the defendant's breath. And during the interview, the defendant stated that she was going to lose her job, she was going to lose her husband, and that she couldn't do this because if she gets a DUI. The defendant did admit to one officer that she took 3 whiskey shots prior to driving, but then she told another officer that she only had 2 shots. The police report did note that the gate was disabled due to the defendant striking the gate with her car. And additionally, the officers did conduct a sobriety test. And while the defendant was out of the vehicle, they noted that the defendant's body was swaying back and forth. And during the horizontal gaze test, the defendant had to be instructed twice on what to do, even after she stated that she understood the instructions. And when doing the test, the defendant continued to move her head. And then, Your Honor, the officer did conduct a BAC, which her level was 0.306. For these reasons, the state's recommendation is a $5,000 surety bond, $4,000 for the DUA, 0.08 grams, and $1,000 for the DUI less safe. no alcohol, drugs, or weapons while out on bond, as well as no driving without DDS approval.
Thank you, Your Honor. Your Honor, Ms. Spalding stands or sits before the court, 51 years old, and having never had involvement with the criminal justice system before. She has always been employed throughout her adult life. She's a paralegal at a law firm and has had a very successful career in that industry, working for law firms that practice family law. And she's married to Lauren Spalding, who is on the video as a listener with his video muted. They reside together, they have children, she maintains steady employment, and if the past is any predictor of her future under the Ayala factors, there will be no issues undermining Ms. Spalding's compliance with the law, compliance with court orders, and appearance in court as directed. While bond hearing, Ms. Spalding stands before the court presumed not guilty. She is a good risk on bond under all of the Ayala factors, and we'd ask the court to issue a UJR bond and allow her to be released in danger.
DUI 0.08 grams. It's going to be $1,000 surety. For the less safe, a $500 surety makes a total of a $1,500 surety. No drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Spalding.
Thank you, Your Honor.
Yeah, you're welcome, Ms. Steele.
Judge, can go back to position number 15, please.
Good afternoon, Ms. Mahan. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 23 CR 003565C with battery, family violence, and cruelty to children in the 3rd degree. Is there a history, Ms. Jackson?
The defendant does not have any prior arrests on file. Nothing in addition, Your Honor.
Thank you. Ms. Bickerstaff?
Yes, Your Honor. So this incident happened on June the 3rd of this year at 2492 St. Paul Avenue. And this is where officers arrived and they noticed an elderly woman standing outside of a car and another woman signaling for them to come toward the car. And so when the officers did walk over to the car, they noticed a lady who was the defendant inside of the car punching another woman who is the victim in this case, Miss Yvette Mahan, the defendant's mother. Both Miss Mahan, the mother, and the defendant were detained in this incident, and PA, who is 11 years old, who is the defendant's niece, she was present and she witnessed the incident occur, and she told officers that the defendant kicked Miss Yvette Mahan, the mother, in the chest during the argument. Officers noted that Miss Mahan, the mother, sustained a scratch while the defendant sustained a swollen eye, Your Honor. Our office was able to speak to Miss Yvette Mahan, and she stated that a violent incident has only happened one other time years ago between her and the defendant. She stated that she didn't even remember what they were arguing about and how it got physical. She also let us know that she didn't sustain any injuries and that she's not in fear of the defendant, and that she also wants contact and wants the defendant to return home. However, Your Honor, this incident did just occur 2 days ago, so the state wants to make sure there is an adequate cooling off period. So the state's recommendation is a $4,000 surety bond, $3,000 for the battery, family violence, and $1,000 for the cruelty to children. No further contact with Miss Mahan, Miss Yvette Mahan, her mother, and to stay away from 2492 St. Paul Avenue, as well as no alcohol, drugs, or weapons while out on bond. And if Miss Mahan's on the Zoom, I would like to sound for her.
Ms. Myhand is present and would like to address the court now. Is your opportunity to do so. Doesn't appear so, Ms. Bickerstaff. Ms. Kim?
Yes, Your Honor, Miss. My hand is 32 years old. Your Honor, she was born and raised here in Georgia. I believe her mother, Miss Yvette, was arrested together. However, she's not on today's calendar. My client was the very one who called the police at that incident. Miss Yvette was drunken and my hand wanted to just, she was basically protecting her to make sure that she was holding her mother's down to push her away from continuously punching her. So I would like, it was more than self-defense. My client is totally okay with no further contact with her mother and stay away from her mother's residence, since she is a caregiver for her grandmother who has a different address, and she will be there to take care of her. She graduated from high school, she has an associate degree, and also she has a new job starting next Monday. She's really excited to go to orientation to get the badge for her security job, and I don't want her to miss her job. We would like to request for a signature on bond. Thank you.
For the battery, it's going to be a $1,500 signature bond through pretrial per the judge. For the cruelty, a $500 signature bond through pretrial per the judge, makes for a total of a $2,000 signature bond through pretrial. 1-day anger awareness, no further violent contact with Miss Yvette Myhand, no drugs, alcohol, weapons while out on bond. Good luck to you, Miss Myhand.
Thank you.
Miss
Is
Wills.
there stairway in there?
No, there's not. There's no further violent contact. Ms. Wills, you've requested a medical reset for Ms. McGee, position number 13,
Yes, sir.
and you'd like that reset for tomorrow?
Yes, please.
Okay, so June 6th. So I'm not sure who needs to make a note of that, but we'll have Ms. Vanessa McGee, position 13 tomorrow, June 6th.
Thank you.
Okay.
Position number 2, Brown.
Good afternoon, Mr. Brown. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Good afternoon, yes, sir.
Yes, good afternoon, sir. Mr. Brown, you've been charged in case 23 CR 003571J with willful obstruction of a law enforcement officer. Is there a history, Ms. Jackson?
Yes, the defendant has 2 cycles. The defendant's last arrest was November the 18th, 2022 in Fulton County for driving while license suspended or revoked. The defendant does have 1 misdemeanor conviction. It's in 2023 out of Alpharetta, Georgia, for expired license. The defendant does appear to meet the criteria for UJR through the jail. Nothing in addition, Your Honor.
Yes, Ms. Bickerstaff?
Yes, so this incident occurred June the 3rd of this year at 9307 Collingwood Lane. And this is where officers arrived and they spoke with a Miss Milan Danford. She called the police explaining that she was afraid for her life while having an argument with her boyfriend, the defendant. And Miss Danford told officers that when the defendant drinks, he becomes very aggressive and angry. But she did state that he did not put his hands on her on this day. When officers arrived and they spoke with the defendant, he refused to explain what happened between him and Ms. Danford. Then he started explaining that he was stronger than the officers and that he could take both of the officers. And then after a while, the defendant told officers that Ms. Danford and him were arguing. They were arguing because he went through her phone and that someone had texted her saying that I'm going to tell. And then the defendant then began getting aggressive toward the officers. He started walking toward the officers in an aggressive manner while pulling up his pants. And so then when the officers tried to detain him, he resisted arrest by pulling his arms away and refusing to put his hands behind his back, Your Honor. For these reasons, the state's recommendation is a $3,000 signature bond through pretrial services and ADET, as well as no further violent contact with Miss Milan Danford, as well as no alcohol, drugs, or weapons while out on bond. Our office didn't speak with Miss Danford, but I would still like to sound for her if she's on the Zoom call.
I'm here.
Yes, good afternoon, Ms. Danford. If you would like to address the court, I need for you to raise your right hand for me. Do you swear
Can you
affirm the
see me?
testimony? Yes, I can see you, ma'am. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay, what would you like to tell the court, ma'am?
First of all, we were intoxicated that night, and I called because we were arguing. Mr. Brown did not, he explained what was going on to the officers. What happened was that the officers accused him of drinking and driving, which I can prove that he was not in a vehicle. We were both not in vehicles. We took an Uber that night. And the reason why he started to get upset is because they accused him of drinking and driving. And also what they told me was that he was spelling his name correctly, and the officers misheard him and accused him of lying about his name, which is totally untrue. I believe that this charge is just from the extremes of the officers, with them accusing him of drinking and driving, which I have proof as to he did not do. I was there. The reason why I called, which is on the recording, I was not afraid for my life. I wanted them to diffuse the situation between us because, like I said, we were intoxicated. We have had no further arguments before this. He has never been violent with me. He's never put his hand on me, ever. And the reason why I called was so that they can support us in diffusing the situation. And instead, they decided to accuse him of drinking and driving and misspelling or giving wrong, incorrect information for his name. He never refused to tell the story. I was there. He told the story in full. I heard him explaining it. He even added additional detail as to what pertained before the event. And he never incorrectly gave a name at all. This is just simply an extreme case of them accusing him. And of course, when you're accused for a wrongful conviction or anything similar to that, there are going to be some negative reactions and feelings to that. He was never aggressive with me, and he was never aggressive with them.
Thank you, Ms. Danford. Who's representing Mr. Brown?
This is Ms. Kim's case. Okay.
Okay, Ms. Kim, Ms.
Yeah.
Kim, I'm gonna give him $1,000 signature bond through the jail. No further violent contact with Ms. Danford, and no drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Kim?
Yes, Your Honor.
Okay, good luck to you, Mr. Brown. You also, Ms. Danford.
Thank you, Your Honor.
You're welcome.
Hey, I have position 16, Judge. I'm sorry.
Now, you're fine, thank you. This is Ms. Miles. Good
Yes,
afternoon.
Judge.
Good afternoon, Ms. Miles. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Miles, you've been charged in case 23 CR 003586G with battery, family violence, and cruelty to children in the 3rd degree. Is there a history, Ms. Jackson?
No, the defendant does not have any prior arrests on file, Your Honor. Nothing in addition.
Thank you. Ms. Bickerstaff?
Yes, Your Honor. So this incident occurred on 5/5/2023, and it was at 61 10 Peachtree Dunwoody Road. And this is where the defendant grabbed and threw a bag filled with hard objects at Mr. Paul Walton. Officers noted that he suffered a bruise and a laceration to his forehead. The defendant's daughter was present during this altercation. Her initials are JW. And our office was able to speak with Mr. Walton, and he stated that the two of them have a 10-year-old daughter, Miss JW, but they do not reside together. He let us know that on the day of the incident, he got a hotel for himself, the defendant, and their daughter so they could spend time together. And Mr. Walton was on the phone with his manager, and that's where the defendant got upset, thinking that he was on the phone with another woman. And so even though they're no longer together, and so he let us know that the defendant stormed out the room, slamming the door, waking up their daughter who had school that morning. And he let us know that the defendant then came back in the room and she tried to argue with him, and then she started trying to provoke him. And so she picked up a bag and it had a lot of hard items in it, one of the items being a screwdriver, and it hit him in the head, Your Honor. Mr. Walton let us know that he does not want any contact with the defendant, and he would like a third-party escort. And he also said that he does not want a stay-away order because he does not want the defendant knowing where his address is. He feels that no further contact would be sufficient for this, Your Honor. The state's recommendation is a $4,000 surety bond, $3,000 for the battery, family violence, and $1,000 for the cruelty to children. 1 day anger awareness, no further contact with Mr. Paul Walton, no alcohol, drugs, or weapons while out on bond, and a third-party escort for their daughter, Your Honor. And if Mr. Walton is on the Zoom call, I'd like to sound for him.
Mr. Walton, if you are with us and you'd like to address the court, now is your opportunity to do so.
I just wanted to first say,
Hold on, Mr. Walton, if you would like to address the court, I'll need for you to activate your camera and I'll have to swear you in, okay? All right, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
yes, sir.
Okay, you can put your hand down. Yes, sir. What would you like to tell the court?
So one, Naya said that she love you, she miss you, and she hope you get better. Two, I had previously talked to her. She has quite a bit of items at her previous or current resident. I'm not sure how you want to put it. My daughter's stuff over there. We don't know anybody out here. You know what? Me personally, I don't know multiple people, and I don't trust my daughter's information over there. And I'm pretty sure she feels the same way. So she has items over there at that residence where she got arrested at, and I know she got a bunch of her stuff over there that's valuable information. And I don't want for them because they got into altercation over there, and I don't want by her being gone or how long she's going to be gone away from that residence for any of that stuff to be thrown away, because it has like my daughter's social security, a lot of valuable information that people that are scammers can use. And I don't want for any of that stuff to be floating. So she asked me to get it. She asked me to get it for her, but I was waiting to this day so I can at least, come to agreement. So that way I can know what I need to do to get at least my daughter's things until, we come to agreement on when she's better for she's be able to have Naya back in a home and safe for, and, in a better living stability and a better, environment as far as mentally and physically for our child. I don't got no ill or hard feelings towards any situation. I just want her to be better. She a good worker, she a good mama. She take care of business, as far as a mother. It's just when it comes down to me and her, and the co-parenting and me trying to be a father to my daughter, it's always friction. So, this will help, the situation, but I just feel like, she needs to be better. She needs more guidance and not guidance from people who say they there for her, you know what I mean? Because a person can say they there all because they trying to use you, and
Excuse me, Mr. Walton. I'm sorry, excuse me, Judge Morrow. Thank you, Mr. Walton, for coming here. I just wanted to get us back on track a little bit. Can I ask a few questions, Judge Morrow, to Mr. Walton?
Yes, that's fine with the court, Ms. Bickerstaff.
Okay, yes, Mr. Walton, how you doing today?
I'm hanging out. I took a break on work just listen to this, what's going on.
Okay, thank you. Thank you for being here. Mr. Walton, it's true that you spoke with our victim witness advocate today, right?
Yes, ma'am.
And you let her know that you do not want any further contact with the defendant, correct?
Yes, ma'am.
Okay, and you do not want a stay away order from the defendant because you do not want the defendant to know your current address, is that correct?
Yes, ma'am.
Okay, thank you. That's all we need, Mr. Watson. We appreciate you speaking with us, okay?
Yep.
All right.
Ms. Kemp?
Yes, Miss Miles is actually a victim of domestic violence. She ran away from Mr. Paul Walton. She was born in Illinois. She's 33 years old. She's been here in Georgia for the last 2 years. And ever since she ran away from Mr. Paul, she does not want to have any contact. She is completely okay with a stay away. So we have no objection to no further contact and stay away. My client, after graduating from high school successfully, she's been working at Oregon FDS airplane assembler, and she is also pursuing her education, going to school to become technician for airplane. And she has a good job. She has a daughter that she wants to raise. She has a support system here in Georgia. We would like to request for signature on bond. And for a child, they are not married. I think it is appropriate for Mr. Paul Walton to have a legitimation gone through at the Superior Court, so that way he has a court order to see their daughter. We would like to request for signature on bond. Thanks.
Okay, it's going to be a $2,000 signature bond through pretrial for the battery family violence, $1,000 signature bond through pretrial per the judge for the cruelty to children, make for a total of a $3,000 signature bond through pretrial per the judge, 1 day anger awareness, no further contact with Paul Walton, and stay away from Mr. Walton's address. There'll be third-party transfer of any minor children for visitation, and no drugs, alcohol, or weapons while out on bond.
So what is the address that they want to stay away from?
Just whatever. I don't know what his address is. Apparently, Ms. Bickerstaff doesn't know what his address is either.
Yes,
So
he doesn't feel comfortable giving us the address because he does not want the defendant to know where he resides.
So we have a stay away, no further contact with Mr. Walton, and let's just say, and stay away from his place of residence.
Judge, was
Okay.
that $3,000 signature bond through the jail or trial? I'm sorry.
Through pretrial.
Okay, thank you.
You're welcome. All right, good luck to you, Ms. Miles.
Position 3, Butler.
Good afternoon, Mr. Butler. I'm Judge Eric Mora. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Butler, you've been charged in case 23 CR 003582Y with loitering and prowling and driving while your license was suspended or revoked. Is there a history, Ms. Jackson?
Yes, the defendant has 9 adult cycles. I'm sorry, excuse me. The defendant last arrest was November the 3rd, 2021 in Fulton County for driving without a valid license. The defendant does appear to be on probation in Fulton County for entering an automobile with the intent to commit theft. That case number is 19 SC 165003. That disposition date was February the 5th, 2020, and the term is for 4 years. He does have prior felony convictions, one in 2020 for theft by receiving stolen property. And there was one in 2021 out of Cobb County for burglary in the second degree. And there was one in 2017 out of Henry County for burglary, smash, and grab. And he has a history of failure to appear. There's one in 2020, one in 2019, and one in 2016. Nothing in addition, Your Honor.
Ms. Falk?
Your Honor, I'm also seeing conviction under 20 SC 174258, multiple counts of theft by receiving stolen property, acquiring a license plate for concealing identification, and possession of a firearm by a convicted felon. So that is in addition to the entering auto case that he had under 19 SC 165003. Those were two separate convictions. The case that we have today, Your Honor, involves this defendant approximately May 14th of 2022. He and another defendant by the name of Nicholas Johnson were seen driving around in the parking deck at 275 Far Road in Atlanta, Georgia. When the officers saw the vehicle, they saw the vehicle driving up with one individual driving and then driving back down where the persons inside the vehicle had switched. And then the other individual was driving. They went back and were able to catch up with Mr. Nicholas Johnson, but did not catch the defendant, Mr. DeQuavius Butler. Nicholas Johnson then, and the vehicle that was being driven had a stolen Virginia license plate, UBL 9402. Mr. Johnson was the one who identified his co-defendant as Solid. They then used social media page and Instagram to identify the defendant based on the identification they had made when they saw the defendant and based on what they then located on his social media and his information and booking information. They then were able to discover that the defendant had a suspended license effective February 7th of 2022. When they went back and watched the video, they were able to observe defendant Johnson, who was the co-defendant in this case, but looking into the vehicle windows in that parking deck at 275 Bar Road. That defendant has subsequently was charged with felonies and then was prosecuted and sentenced. This defendant, as Your Honor is aware, is charged with loitering and prowling, and we did charge it as a party to a crime in conjunction with Mr. Nicholas Johnson, as well as having a suspended license. Given the defendant's prior history, particularly involving multiple entering autos and theft by takings, as well as theft by receivings, and given what was seen on that video the day of, which was the defendant driving Mr. Johnson to that area where Mr. Johnson then proceeded to go and look through the windows of the vehicles, we are asking for a $4,000 surety bond, $3,000 on the loitering and prowling, $1,000 on the suspended license. We are asking that the defendant not drive unless he has a valid license. And we are asking that he stay away from 275 Far Road in Atlanta, Georgia. We are also requesting no alcohol, drugs, or weapons as part of our plea recommendation. That area of 275 Far Road is, my understanding, is an apartment building, and I can pull the name for Your Honor shortly. Thank you.
Ms. Wells?
Thank you. Mr. Butler is 25 years old. He is a native of Georgia. He is employed through or by Keep It Cool as a delivery man, and he's been employed there for the past 3 years. He will not qualify to be represented by the Public Defender's Office. He is the father of 4 children. He does deny the allegations as alleged. This incident occurred over a year ago. My client has not been arrested since then. No other offenses were listed or noted today. Since that time, I would ask for a signature on bond. And if your honor is not so inclined, I would ask for a $2,000 surety bond, as this is just a loitering, prowling, and drive without a license case. And my client has rectified his driver license issue and does have a current valid driver's license currently.
Ms. Falk?
We were unable to locate the name of that apartment building, Your Honor. We just know that it was a parking deck.
Okay, for the loitering and prowling, it's a $750 surety bond. Driving while license suspended or revoked, a $250 surety bond, makes for a total of $1,000 surety bond. Stay away from 275 Fall Road. Of course, no driving without a valid license, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Butler.
All right, thank you.
You're welcome.
Position 6, Diggs.
And is this going to be the plea, Ms. Falk?
Yes, Your Honor. There are actually 3 on the calendar today. We have sent all of the paperwork to Ms. Katrina Lewis.
Okay, and so it's all been completed?
Yes, Your Honor.
Okay, thank you. Good afternoon, Mr. Diggs. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear for any testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, Mr. Diggs, let me first advise that you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. We have provided you with the assistance of a public defender, but it is my understanding that you wish to proceed without the assistance of counsel and enter into a plea to this criminal trespass charge. Is that correct?
Yeah.
Ms. Falk, what was the state's recommendation for the criminal trespass?
State's recommendation is 12 months probation, 1 day jail, credit for time served, release time served, and stay away from the Georgia World Congress Center building at 285 Andrew Young International Boulevard. The facts on this case are that on June 3rd, defendant entered inside without consent. He had been previously given a criminal trespass warrant on June 3rd, 2023. And on June 4th at 12 a.m., he was located in the A building after having previously been given a warning to stay off the property.
Okay, was that your understanding of what the offer would be, Mr. Diggs?
Yeah.
And is that what you would like to accept to resolve the matter today?
Yeah.
Okay. Did you have something, Ms. Lewis?
I'm kind of confused because y'all saying probation and I don't have probation on the line. So you said, are you saying?
No. My apologies. I may have left out that the probation is suspended. The balance is suspended.
So it should be balance suspended instead of saying probation. So when you say probation, it makes me seem like I need to have probation on the line.
My apologies. And in the Senate sheet, it does say balance suspended. So
okay, so it's 12 months balance suspended.
Yes, ma'am.
Thank you.
Right.
Also, Ms. Wills did put in the chat that the defendant will need a escort to pick up his belongings that are at the Georgia World Congress Center.
Okay. And a one-time escort to the Georgia World Congress Center?
Yes, Your Honor.
Mr. Diggs, it's my understanding that in case 23 CR 003579G, you wish to plead guilty to criminal trespass. Is that correct?
Yeah.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've been given the opportunity to be represented by counsel. It's my understanding that you wish to proceed pro se without the advice of counsel. Is that correct?
Mm-hmm. Yes,
Is
sir.
that- you understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
You had the opportunity to go through the plea sheet in this matter. Is that right?
Yes, sir.
Did you go through it line by line?
Yes, sir.
And did you sign the bottom of it?
Yes, sir.
And did anyone force or coerce you to plead guilty?
No, sir.
I will accept your plea as negotiated, Mr. Diggs. You're not to go back to the World Congress Center, but you can go back there on one occasion with law enforcement to retrieve any belongings that you might have there, okay?
Yes, sir.
All right, good luck to you, Mr. Diggs.
All right, you too.
Position 8, Grimmett.
Good afternoon, Mr. Grimmett. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good afternoon.
Good afternoon, sir. Mr. Grimmett, you've been charged in case 23 CR 0035778C with criminal trespass and damage to property. Is there a history, Ms. Jackson?
The defendant has 5 cycles. The defendant's last arrest was January the 23rd, 2021 for aggravated stalking and simple battery, and possession of marijuana with the intent to distribute, and possession of Schedule 1 or 2 controlled substance with the intent to distribute, and possession of cocaine with the intent to distribute, and possession of drug-related objects. And that was in DeKalb County, Georgia. The defendant does appear to be on first offender probation in DeKalb County. It's 2 different cases. The first case is for the aggravated stalking and possession of marijuana with the intent to distribute, and possession of Schedule 1 or 2 controlled substance, and possession of cocaine with the intent to distribute. That disposition date was April the 11th, 2022, and the term is for 4 years. And also he's on probation for aggravated assault. Has the same disposition date of April the 11th, 2022, and the term is for 4 years. And there was no seal date listed in the GCIC, nothing in addition.
Yes, Your Honor. This incident happened June 4th, 2023 at 6:55 a.m. at the Circle K at 111 Boulevard Northeast in Atlanta, Georgia. Officers responded and spoke to the employee over at Circle K who stated that an individual later identified as the defendant broke the right glass door of the business. Officers were able to view a video which showed the defendant and a female by the name of Miss Bettis in a verbal argument in front of the gas pump. Miss Bettis then walked toward the front door of the business, and as she opened the right door, the defendant kicked and cracked the glass. The video from the inside of the Circle K shows that the glass had not been damaged prior to the defendant kicking it. The reason the officer knew these individuals is they had been in an accident prior to the officer responding to that location where Ms. Bettis had been in an accident and the defendant had been also driving at that time a different vehicle. So the officer was able to identify him from their previous interactions and then responded to Grady Hospital and placed the defendant under arrest for the criminal trespass. The defendant's bond is currently set at $1,500. The state would recommend to reduce that to $500 surety. Stay away from the Circle K at 111 Boulevard Northeast, Atlanta. No alcohol, drugs, or weapons. That's all for the state.
Ms. Wells?
Thank you, Judge. My client is 30 years old. He has resided in the state of Georgia for the past 7 years. He is currently employed by Sweet Potato as a sous chef, and he's been employed there for the past 4 years. He will not qualify to be represented by the Public Defender's Office. He is the father of 6 children. He does deny the allegations and states that the door was damaged prior to him being at that gas station. And I would request a signature on bond, and if Your Honor is not so inclined, I would ask that the state's recommendation of $500 surety be ordered. Thank you.
It's going to be a $3,000 signature bond through the jail. Stay away from the Circle K on Boulevard. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Grimmett.
$3,000 signature bond. How much is that?
You don't have to pay nothing.
Okay, thank you.
Position 9, Heath.
And this will be another plea, Your Honor.
Good evening.
Thank you. Good afternoon, Mr. Heath. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Heath? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down, Mr. Heath. Mr. Heath, you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. We've provided you with the assistance of a public defender this afternoon. It's my understanding that you wish to proceed without the assistance of counsel and enter into a guilty plea on this charge of criminal trespass. Is that correct?
Yes, sir.
What is the recommendation, Ms. Falk?
Your Honor, state's recommendation is 12 months to serve 1 day in jail, balance suspended, and stay away from MARTA, 5 Points MARTA station until the expiration of his active suspension, which is June 16th of 2023.
Is that what you understand the recommendation to be, Mr. Heath?
Yes, sir.
Okay, go ahead, Ms. Falk.
Yes, Your Honor, just briefly, June 2nd, he was observed trying to enter while intoxicated. He had previously had an active suspension that was effective April 17th, 2023 and expires June 16th, 2023, at which point he was arrested.
It's my understanding, Mr. Heath, that in case 23 CR 003577C, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've had the opportunity to be represented by counsel. It's my understanding that you wish to proceed without the representation of counsel. Is that correct?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Did you have the opportunity to go through the plea sheet in this matter?
Yes, sir.
Did you go through that sheet line by line?
Yes, sir.
And did you sign the bottom of that sheet?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Heath. Now, you know you can't go back to MARTA until that suspension's up, right?
Yes, sir.
All right, good luck to you, Mr. Heath.
Sir.
Position 11, Jacobs.
Good afternoon, Mr. Jacobs. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Jacobs, you've been charged in case 23 CR 003575F with battery family violence and simple battery family violence. Is there a history, Ms. Jackson?
The defendant does not have any prior arrests on the file, Your Honor. Nothing in addition.
Ms. Falk?
Yes, Your Honor. This incident happened June 4th, 2023 at 3000 Continental Colony Parkway Southwest, Atlanta, approximately 6 a.m. The defendant and Miss Marie Johnson, his wife, were in an argument. The defendant pushed Miss Marie Johnson as though he were trying to push her out of the house. Ayanna Johnson, his sister-in-law, came out to see what was going on, and the defendant turned his anger on her. He placed her in a headlock and began choking her. Miss Ayanna Johnson stated she couldn't breathe, thought she was going to pass out, and Miss Marie Johnson had to pull the defendant off of Miss Ayanna Johnson. Officers were able to observe bruises to Miss Ayanna Johnson's leg and neck. We did have an opportunity to speak with both Marie Johnson and with Miss Ayanna Johnson. Miss Marie Johnson stated that she and the defendant live together. They share 4 children, and the defendant had called her phone and she did not answer, and he accused her of doing something with someone else. They got into an argument. The defendant pushed her and was trying to kick her out of the house and trying to throw her belongings out of their home. She stated that her sister came out to see what was going on, tried to stop the defendant from throwing her belongings out. That is when the defendant attacked her sister. She stated this is not the first time the defendant has been violent with her, and that the defendant pushes her all the time. Although that is occurring in the home, Miss Marie Johnson stated she is not in fear of the defendant, wants contact, and wants him to return. We also spoke with Miss Ayanna Johnson, who is the sister-in-law of the defendant. Miss Ayanna Johnson stated she came out of her room to see what was going on. The defendant turned his anger towards her. He was on top of her with his arm on her neck, choking her. She said she couldn't breathe. She felt like she was going to pass out. She said that this occurred for about 30 seconds to a minute. and her sister was trying to pull him off of her. Miss Ayanna Johnson stated the defendant then tore her robe off and kicked her out of the house, and she was outside nude. She stated this is not the first time the defendant has been violent with her, and this does happen all the time. She stated she's called the police on the defendant in the past, but no arrest has been made, and that she is done. She does not want any contact with him, and she plans on leaving the residence and going back to New York. I would like to sound for both of them when appropriate. I will also say we had an opportunity to listen to the jail calls between the parties, including Mr. Jacobs, the defendant, and that at some point, Miss Johnson stated she did nothing wrong. And when she also spoke to him and said, what's going to happen when you come back? And she stated she may have to defend herself. And then the defendant stated nothing was going to happen, and they began arguing.
Judge, calls are inappropriate at this stage. There's an evidentiary hearing that would need to happen in order to be able to get that information in, and for the state to try to introduce that at this stage where he's presumed innocent. And this is not a preliminary hearing, it's not a trial. It's inappropriate to talk about the contents of a jail call, which none of us have, which we can't verify, which they have to lay a proper foundation to even be able to introduce it. And we're concerned, we know the court can see through it, but we're concerned this is being streamed all over the internet. Potential jurors are hearing this, and it's just not what should happen at this stage. So we would ask the court not to allow the state to do that.
Your Honor, may I have an opportunity to respond?
Thank you, Mr. Howard. Yes, Ms. Falk.
Your Honor, I will say a couple of things. One, the state has access to plenty of things the PD's office doesn't have access to at a bond hearing. We have access to police reports. That is not objected to. We have access to jail calls. All of those are things that we can provide the court to instruct them as far as the IALA factors are concerned and are related to the IALA factors, particularly the risk of intimidation of witness. As far as this being broadcast to potential jurors, so are the potential facts of the case. So I would just respond to Mr. Howard's concern with that is part and parcel of all of the information the state is permitted to provide to the court, and the court, as an officer of the court, I am providing that information. As the court, Your Honor, can determine whether that information weighs toward the IALA factors or not.
And Judge, my issue is, again, if this were a closed proceeding, we might have a different take on it. But police reports are things that are clearly admissible or can be referred to in any trial type of a situation. But these types of evidence, such as DUI, breath tests, and jail calls, these are things that are not admitted except there be a foundation laid, and that there's a process the state has to go through to be able to introduce this. And so at this stage, where it's not an evidentiary hearing, we don't have any of those issues at this stage. We're saying it's premature to get into that, Judge. We're just saying police reports, we understand they can give hearsay related to that, but to say we've got jail calls where supposedly our client is making certain statements is inappropriate at this stage, Judge. At this stage, we're not saying they can't do it, but at this stage.
And my response is this is not a trial. So the state does not have to lay a foundation.
It is this court's procedure in the past that I allow everyone to speak, and there's certain things that the state objects to that I allow the defense to get into. There's certain things that the defense objects to that I allow the state to get into. I believe that I need the full gamut so that I can make the decision regarding the factors and this bond. So Ms. Falk, if you have anything further, you can let me know.
I do not, Your Honor. We just need to sound from Miss Ayanna Johnson and Miss Marie Johnson.
Okay, either Marie Johnson or Ayanna Johnson are on the line and wish to address the court. Now would be your opportunity to do so.
Hello.
Yes.
This is Marie Johnson.
Yes, ma'am. Can you activate your camera for me?
Okay. Yes.
All right. Yes. Good afternoon, Ms. Johnson. Can you raise your right hand for me?
Can you see me?
You're having internet problems, so see if we can get through it. But if you'll raise your right hand, do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, what would you like to tell me, Ms. Johnson?
I would like to say that I do feel like what happened the other night was out of character, but at the same time, we share a family. We're married. We have 4 kids. It's not something that we can't get through. I feel like he can come home. I'm not afraid for him to come home or afraid for him to be around us. No one else will be in the home with us now after today. So.
Has this happened in the past?
As far as us arguing, yes.
Okay, and is Ayanna Johnson, is that your sister?
Yes.
And she's leaving the residence because of this?
She didn't have really any real intentions on staying with us. She already had a go plan. But with all of this happening, it just happened quicker.
Okay. What else would you like to tell the court?
Anything else you would like to ask?
Ms. Falk?
Yes, Ms. Johnson, do you recall talking to our victim advocate today?
Yes.
Do you recall telling her the defendant pushes you all the time?
Not all the time, but often. But he wouldn't like physically try to hurt me.
Okay, but he has pushed you in the past, is that correct?
Yes.
And on this date, he did put his hands on your sister and choke her.
Yes.
That's all for the state, Your Honor.
Thank you, Ms. Johnson. Ms. Wills?
Thank you. My client is 22 years old. He has resided in the state of Georgia for the past 2 years. He is employed by Amazon as a process manager, and he has been employed there for the past 4 to 5 months. He will not qualify to be represented by the public defender's office. My client does have a high school diploma and attended NYU for 1 year. He is the father of 4 children. He is married to Miss Marie Johnson. I would like it noted that the named victim, the alleged victim, is her sister-in-law who is going to be leaving the residence, as it has been stated. My client states that the argument began between himself and his wife. It was not physical, but he was in the process of putting her belongings outside of the home. That's when Miss Johnson's sister became involved. And she repeatedly hit my client, and he suffered injuries as a result of that attack. He never was physical with her. He did restrain her or attempt to get her away from him, but he denies the allegations that he ever assaulted or hit Miss Johnson. As was stated, the AV, Miss Johnson, Miss Marie Johnson, my client's wife, stated that they have argued before, but she did not say whether or not they have had physical contact before, violence before. So I would ask, in light of this being my client's first arrest, that he be granted a signature on bond. If Your Honor is not so inclined, I would ask that the bond not be over $1,000. And that he have no further violent contact with his wife, Miss Johnson, that he be allowed to return to the residence so long as the alleged victim has vacated the premises as she has indicated. And that will be all. Thank you.
And Your Honor, during my spirited discussion with Mr. Howard, I did neglect to put the state's recommendation on the record, so I would like to do so at this point.
Yes.
State's recommendation is a $10,000 surety bond, $7,500 on the battery, $2,500 on the simple battery. Stay away from 3000 Continental Colony Parkway, Southwest Atlanta. No further contact with Miss Ayanna or Marie Johnson. No alcohol, drugs, or weapons. As Miss Marie Johnson admitted to, the defendant has pushed her before in the past, and we believe that because Miss Ayanna Johnson intervened, that is why she got the brunt of what occurred. And we do have serious concerns for the safety of Miss Marie Johnson, especially now that Miss Ayanna Johnson is no longer present in the residence. That's all for the state.
And the court shares Ms. Falk's concerns. And in addition, I have concerns for those 4 children. You can put your hand down for now, Mr. Jacobs. I will allow your counsel to speak with you if you would like after I address you. I'm mostly concerned for the kids in that household, for what Ms. Marie Johnson has informed the court. You two are grown people, but as far as these 4 kids go, that's a whole different story. I do want you out, Mr. Jacobs, being able to make a living and provide for your children. As such, it's going to be a $3,000 signature bond through pretrial per the judge for the battery, family violence, and a $2,000 signature bond through pretrial for the simple battery per the judge. It'll make it a total of a $5,000 signature bond through pretrial per the judge. 1-day anger awareness. At this point in time, no further contact with Ms. Johnson, and stay away from the Continental Colony address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there, and he is to have third-party transfer of the minor children for visitation. No drugs, alcohol, or weapons while out on bond.
And Your Honor, but Miss Ayana, her last name is Johnson as well as Miss Marie. They're
okay,
both.
so there's no further contact with Ms. Marie Johnson, and there's no further contact with Ms. Ayana Johnson. Okay. Good luck to you, Mr. Jacobs.
Judge, can you repeat the bond again, please?
Yes, 3,000 signature for the battery, 2,000 signature for the simple battery through pretrial. Who do we have next?
It's gonna be position 12, Jones. You're done.
Good afternoon, Mr. Jones. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 003574E with loitering and prowling. Is there a history, Ms. Jackson?
The defendant has 1 prior cycle. It was on October 6, 2015 for simple battery, family violence. And that was in Bullock County, Georgia. The defendant received pretrial intervention for that case. And the defendant appeared to meet the criteria for a UJR through the jail. Nothing in addition, Your Honor.
Thank you. Ms. Falk?
Yes, Your Honor, this incident happened June 3rd, 2023 at 872 Boulevard Southeast in Atlanta. Defendant was found sitting on a chair at the property. He stated he was homeless and needed a place to sleep. He was observed on surveillance video twisting the front door handle, attempting to make entry. State's recommendation is a $2,000 signature bond through pretrial services. Stay away from 872 Boulevard Southeast Atlanta. No alcohol, drugs, or weapons. That's all for the state.
I'm going to send that through the jail. Ms. Wills, do you have any objection to any of the other things recommended by the state?
No, I just would like it noted that my client is residentially challenged, and I have had a social worker go out and visit with him about housing resources prior to court.
Okay, thank you, Ms. Wills. So it's a $2,000 signature bond through the jail. Good luck to you, Mr. Jones.
Yes, sir.
And then position 18, pull-ins.
Good afternoon, Mr. Pullins. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. Thank you. Good afternoon, Mr. Pullins. You've been charged in case 23 CR 003566A with simple battery family violence. Is there a history, Ms. Jackson?
The defendant has 35 cycles. The defendant's last arrest was February the 25th, 2017 for a failure to appear, and that was in Fulton County. The defendant does have prior felony convictions. This one in 2011 for financial transaction card theft, one in 2007 for 2 counts of possession of controlled substance with the intent to distribute, and one in 2003 for burglary. And he has misdemeanor convictions. There was one in 2005 for theft of lost or mislaid property. There was an additional one in 2005 for obstruction of an officer, and one in 1995 for theft by shoplifting. Nothing in addition, Your Honor.
Thank you, Ms. Bickerstaff.
Yes, Your Honor. So this incident occurred June the 2nd of this year at the Motel 6, located at 1377 Virginia Avenue in East Point, Georgia. And this is where officers arrived, and they were advised by the front desk clerk that a male in room 311 was beating on his girlfriend. The clerk explained to officers that the girlfriend was screaming for help in the hallway, and that the male, which was identified as the defendant, forcefully pulled Miss Jarmesia Robinson back into the room. And so when officers made contact with Miss Robinson, they noted that she appeared to be in emotional distress, and that she told the officers that she had been staying with the defendant for the past few weeks. She let the officers know that the two were arguing over the defendant using her tablet, and then that caused the defendant to strike her in her back and on the left side of her face. The officers did not know any injuries that they observed on Miss Robinson. The defendant did leave the location, but officers did later see the defendant with Miss Robinson's tablet sitting on a nearby curb. The defendant denied hitting Miss Robinson. However, Your Honor, the officers were able to speak with one of the motel employees, Mr. Swan, who made contact with Miss Robinson before they came. And Mr. Swan let the officers know that when he spoke to Miss Robinson, he asked her what's wrong, and she said, "He's beating me." And then when Mr. Swan asked Miss Robinson, did she need help, she said, "Yes, call the police." And so our office was not able to speak to Ms. Robinson today, but we were able to speak to her grandma. She said Ms. Robinson's grandma let us know that Ms. Robinson does not have a cell phone, but the grandma does believe that the victim, Ms. Robinson, fears the defendant. She also stated that Ms. Robinson's mother has had to take out a warrant on the defendant in the past for stalking Ms. Robinson. Your Honor, Ms. Robinson's grandma did say that she was going to let her know about the call, Your Honor. The state's recommendation for all these reasons is a $3,000 surety bond, 1-day anger awareness, no further contact with Ms. Robinson. Her first name is Jarmesia, that's Jarmicia, and to stay away from the Motel 6 at 1377 Virginia Avenue, only if Ms. Robinson is still living there, as well as no alcohol, drugs, or weapons while out on bond. And if Ms. Robinson is on the Zoom call, I'd like to sound for her.
Ms. Robinson, if you are with us, this is your opportunity to address the court. Doesn't appear so, Ms. Bickerstaff. Yes, Ms. Montoya, I will allow you to address the court. Let me speak with Ms. Kim first, and then I will I'll allow you to address the court, ma'am.
Okay.
Ms. Kim?
Yes, it seems like there was a lot of hearsay, grandmother, mother, Swan, all those people, not directly from Miss Robinson, but anyway, we would like to request for signature on bond. He is 60 years old, Georgia native. He's been working with PAD. Alicia Montoya is actually the supervisor for that care navigator, to work for his housing, to get his life straight. He's been working as a landscape worker, and he's been also, let me see, I kind of lost that. He's been working to get the housing straight. He has actually child right now with Jarmicia Robinson, and 1 year and 2 months old, and that child is under foster care. So Mr. Pullins has been working hard to have a stable place for her baby to return home. And he denies the allegation. There was no such thing. We would like to request for on bond. Thank you.
Yes, Ms. Montoya, if you would like to address the court, I'll need for you to raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Yes, ma'am.
Okay, so I am Carl's care navigator at the PAD program. I did want to confirm that he has the Georgia housing voucher that he's approved for. And prior to the incident on Friday, I had scheduled to meet him at an apartment complex that he had applied for to see if it was move-in ready for him. And Mr. Pullins is staying at the Motel 6 that the PAD program is providing for him. So the PAD program is paying for him to stay there until he transitions into permanent housing. So we would like for him to return just because it is being provided for by the PAD program, and we were not aware that Mr. Amisha was staying with him for the past couple of weeks.
Okay. Thank you, ma'am. So it's going to be a $3,000 signature bond through the jail. No further contact at this point in time with Ms. Jormisha Robinson. Third-party transfer of the minor child for visitation if that's necessary. And no drugs, alcohol, or weapons while out on bond. Mr. Pullins, I'm going to allow you to sign your own bond so that you could get out. But you have to make sure that you return at the appropriate time and keep the court informed of when you do get some stable permanent residence of what your address is so that the court, so that you can be notified of your next hearing date, okay?
That's John. Thank you, Mr. Lee.
All right. Good luck to you, Mr. Pullins. Thank you, Ms. Montoya.
Position 19, Shanks.
And it's my understanding that this is going to be a plea also.
Yes, Your Honor.
Good afternoon, Mr. Shanks. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Shanks, you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. We have provided you with the assistance of a public defender today. It's my understanding that you wish to proceed without the assistance of counsel and enter into a plea. Is that correct?
Yes, sir.
Okay, the charge is criminal trespass. What is the offer, Ms. Bickerstaff?
Yes, it's 12 months to serve, 1 day credit for time served, that 1 day balance suspended, and to stay away from the Shell gas station at 556 Northside Drive. Your Honor, just quickly for the record, this incident.
Okay, hold, Ms. Bickerstaff, I don't mean to interrupt you. I just want to make sure that that's what he has understood and that that's what he is going to accept. Is that your understanding of the recommendation, Mr. Shanks?
Yes, sir.
Is that what you'd like to accept?
Yes, sir. Just stay away from that gas station. Yes, sir.
Yes, sir. Okay. All right, hold on for me. Yes, go ahead, Ms. Bickerstaff.
Yes, Your Honor, this incident occurred June the 3rd of this year at the Shell gas station at 556 Northside Drive. And this is just where the defendant entered and remained on the property after being asked to leave and after he's been issued several criminal trespass warnings previously.
Okay. Mr. Shanks, it's my understanding that in case 23 CR 003567G, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've been represented by counsel, or you have had the opportunity to be represented by counsel. It's my understanding that you wish to proceed without the assistance of counsel. Is that right?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Did you have the opportunity to go through the plea sheet in the matter?
Yes, sir. I saw the plea sheet.
Okay, did you go through that sheet line by line?
Yes, sir.
And did you sign the bottom of it?
Yes, sir.
Did anyone force or coerce you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Shanks. Good luck to you, sir.
Sir, yes, sir.
All right.
Position 21, Spear.
Yes, sir.
Good afternoon, Mr. Spear. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. Mr. Spear, you've been charged in case 23 CR 0035669H with reckless conduct. Is there a history, Ms. Jackson?
Yes, the defendant has 32 cycles. The defendant's last arrest was December the 26th, 2022 in Fulton County for obstruction of an officer in possession of marijuana less than an ounce and possession and use of drug-related objects. The defendant does appear to have an open case pending for obstruction of an officer in possession of marijuana less than an ounce and possession and use of drug-related objects. That's in Fulton County. That case number is 22 CR 00852 5 and the letter H. The defendant does have prior felony convictions. This one in 2018 for possession of cocaine with the intent to distribute. One in 2016 out of Gwinnett County for possession of cocaine with the intent to distribute. And one in 2015 out of DeKalb County for possession of cocaine. And one in 2007 out of Cobb County for possession of marijuana with the intent to distribute. And one and for possession for possession of controlled substance. And there was one in 2006 out of Cobb County for obstruction of an officer. And he does have misdemeanor convictions and sentences. There's one in 2019 out of DeKalb County for giving false information to an officer. And one in 2014 for theft by shoplifting. And he received a nolo contendere sentence in 2012 for driving while license suspended or revoked. And he received a nolo contendere sentence in 2010 for possession of marijuana less than an ounce. And there was one in 2005 for obstruction of an officer. An additional one in 2005 for theft by shoplifting. Nothing in addition, Your Honor.
Ms. Bickerstaff?
Yes, Your Honor. So this incident occurred yesterday at 39 Georgia Avenue. And this is where officers received a call that a Black man in the area was waving a knife over his head. And then officers received another call that a Black man with jeans and a white shirt had just assaulted another male in the same area. Officers were able to find a male matching that description, the defendant. And so when they approached the defendant, he dropped a long Black object. And then the victim in this case, Mr. Quan Henderson, that's K-U-A-N Henderson, he yelled at the officers and said, "That's him." And he advised the officers that the defendant had grabbed him from the back and then put an unknown object to his neck, Your Honor. Mr. Henderson told officers that he had to kick and push the defendant off of him. And then as Mr. Henderson was explaining this to the officers, another male walked up to the officers and confirmed that he saw the defendant putting an unknown object to Mr. Henderson's neck from behind, Your Honor. For these reasons, the state's recommendation is a $3,000 surety bond, 1-day anger awareness course, a behavioral health evaluation and treatment, no further contact with Mr. Henderson, and to stay away from 39 Georgia Avenue, as well as no alcohol, drugs, or weapons while out on bond. And I don't believe Mr. Henderson is on the Zoom call, but I would like to sound for him.
Mr. Henderson is with us, and would like the opportunity to address the court. Now is that opportunity. Doesn't appear so, Ms. Bickerstaff. Ms. Kim?
Yes, Your Honor. Mr. Spear is 42 years old. He was born and raised here in Georgia. Your Honor, he has a ties to the community. His aunt is here as an emergency contact. He has been working at State Property Movers as a mover. He graduated from high school here in Georgia. Your Honor, he is actually not going to be qualified for public defender's services because of his job and his income. Your Honor, my client denies the allegation. We would like to request for a signature on bond, and yet if Your Honor is not inclined to give him a signature on bond, we would like to request for a maximum $2,000 good bond. Thank you.
It's going to be $1,000 surety bond, no further contact with Mr. Kawan Henderson, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Spear.
Thank you, Your Honor.
You're
Position
welcome.
22, Stanford.
Good afternoon, Mr. Stanford. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Good afternoon, Your Honor. Yes, I do.
Thank you, Mr. Stanford. You've been charged in case 23 CR 003589E with battery family violence. Is there a history, Ms. Jackson?
Yes, he has 12 cycles. The defendant's last arrest was June the 1st, 2023 in Fulton County. But no, I apologize, Your Honor. It seems like that's tied in with the current arrest. Prior to that, he was arrested September the 4th, 2020 in Douglas County for the violation of a family violence order. The defendant does appear to be on probation in Douglas County for the violation of a family violence order. That disposition date was June the 28th, 2022, and the term is for 12 months. He does have prior felony convictions, sworn in 2009 out of Cobb County for false statements or writings, and sworn in 2007 out of Cobb County for possession of controlled substance. And there was one in 2001 for possession of cocaine with the intent to distribute. This one in 2000 out of DeKalb County for a charge associated with the CWAC. Nothing in addition, Your Honor.
Thank you, Ms. Jackson. Ms. Bickerstaff?
Yes, Your Honor. So this incident occurred February 15th of this year at 1546 Ridgeway Lane. And this is where Ms. Jermel White's aunt called the police reporting that Ms. White was being assaulted by the defendant, who was her boyfriend. Ms. White advised that her aunt called the police because the defendant had taken her cell phone and that he was upset over cigarettes from the previous day. And then the defendant proceeded to punch Ms. White in the back of the head several times. Officers noted that Ms. White suffered a knot and scratches to her face, Your Honor. Our office was able to speak to Ms. Jermel White, and she stated that she doesn't want to press charges, and she stated that the police report is false. She also let us know that her aunt heard them arguing over the phone, and that's why her aunt decided to call the police. She also let us know that she's not in fear of the defendant and that she wants contact with him and for him to return to their residence, Your Honor. Although she stated that the state's recommendation is a $3,000 surety bond, 1 day anger awareness course, no further contact with Ms. White, and to stay away from the 1546 Ridgeway Lane address, as well as no alcohol, drugs, or weapons while out on bond. And if Ms. Jermel White is on the Zoom, I would like to sound for her.
I see Ms. White there. She appears that she would like to address the court. Good afternoon, Ms. White. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Okay, you can put your hand down, Ms. White. What would you like to tell the court?
It really wasn't what it was. I was actually upset. And by us arguing, and like when he took my phone, I threw my hand up and I had on bracelets. I scratched my own face. Like I said, I don't want him to be down there. We do live together. We have 5 kids together. Everything we do half and half. We split, we pay half and half. I need my husband. just as well as my husband need his kids.
This happened allegedly back in February. Have you all been together since February?
Yes, sir. All the way up until he just recently went to jail. Yes, we also work together as well. We both work at State Farm Marina. So since then, we have not had any arguments. But like I said, I was mad in the moment. And that is all.
And so this hasn't happened. Has it ever happened before? Before that time?
No, never. And
Oh,
the thing that the case prior is with his baby mother that's in Douglas. That's not me.
Are you afraid of him?
No,
Okay.
of course not.
I have to ask you that, Miss White. Okay.
I've been crying since he been in there. I haven't been sleeping. I've been smelling shirts of his scent. No, I need my husband.
Okay. All right, Miss White. Ms. Bickerstaff, do you have any questions?
No questions, Your Honor.
All right. Thank you, Miss White. Ms. Kim? You're on mute, Ms. Kim.
I apologize. I assumed you would give signature on bond. But anyway, Mr. Stanford is 43 years old and they have been living together for about 10 plus years, Your Honor. If he can get signature on bond, he is willing to sacrifice, stay away. I mean, even though that's going to be really, really hard for him, he understands that, but it's been already 3 months. And I really think that that's enough for a cooling period. So no further violent contact is appropriate for this case. And my client graduated from college with an associate degree. He has a science degree and he's working at State Farm Arena as a culinary supervisor. He's not going to be qualified for public defender services. And yet he has to take care of 5 children. Minor children, Your Honor. We would like to request for a signature on bond. Thank you.
Mr. Stanford, I'm going to let you out so that you can continue to take care of your children. So it's going to be a $3,000 signature bond through the jail, no further violent contact with Ms. White, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Stanford. Good luck to you also, Ms. White.
Thank you, Honor. Thank you, Court.
Thank you.
Position 23, Tory.
Good afternoon, Mr. Torrey. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir.
Thank you. Mr. Torrey, you've been charged in case 23 CR 003587A with loitering and prowling. Is there a history, Ms. Jackson?
The defendant has 7 cycles. The defendant's last arrest was November the 4th, 2020 in Cobb County for criminal trespassing. The defendant does appear to be on first offender probation in Cobb County for criminal damage to property in the 2nd degree and aggravated assault. That case was sealed the disposition date was November the 15th, 2022, and the term is for 1 year and 8 months. The case was sealed on April the 18th, 2023. The defendant does have a prior misdemeanor conviction. It was in 2016 out of Kennesaw, Georgia for a DUI. Nothing in addition, Your Honor.
Ms. Bickerstaff?
Yes, Your Honor. So this incident occurred on June the 3rd of this year at 921 Amsterdam Avenue. And this is where the defendant got through a fence and then he began looking inside the property window. The owner, Mr. Neil Resnick, recorded the incident and called police. For these reasons, the state's recommendation is a $1,000 surety bond and to stay away from 921 Amsterdam Avenue. I don't believe Mr. Resnick is on the Zoom, but if he is, I'd like to sound for him.
If Mr. Resnick is present and would like to address the court, now is your opportunity. Doesn't appear so, Ms. Bickerstaff. Ms. Kim?
Yes, Your Honor. Mr. Torre is 29 years old and he has been here in Georgia for about 10 years. He was born in Illinois. However, he has a strong ties to the community. He works at Collier as a driver, and he also is involved in Zion Baptist Church. He's helping out other people to overcome their substance abuse. He volunteers, and he he didn't graduate from high school. He has a GED. He's working full-time as a driver, and we would like to request for a signature on bond. Thank you, Your Honor. No
Okay,
one
it's gonna,
their way.
it's gonna be a $2,000 signature bond through the jail. Stay away from the Amsterdam Avenue address. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Torre.
Position 24, Troutman.
Good afternoon, Mr. Troutman. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good afternoon.
Good afternoon. Mr. Troutman, you've been charged in case 23 CR 003572B with battery. Is there a history, Ms. Jackson?
He has 4 cycles. The defendant's last arrest was April the 26th, 1999 in DeKalb County, Georgia for theft by taking. There was no disposition for that arrest, and there are no convictions listed in the GCIC. Nothing in addition, Your Honor.
Ms. Bickerstaff?
Yes, Your Honor. So this incident occurred June 3rd, 2023 at 1240 Princess Avenue. And Your Honor, this is where Miss Kaya Troutman told officers that her uncle, the defendant, slammed her to the ground, and then he started punching her in the face. Officers observed scratches to her chest, Your Honor. And Miss Kaya told officers that this incident started because the defendant would not allow her to come upstairs to bring her grandmother food. And our office was able to speak to Miss Kaya today, and she let us know that the defendant lives across the hall from her. And she stated that the defendant is supposed to be the grandma's caretaker, but he's been abusing her, and that there is an open adult defects case right now. She also let us know that she filed a TPO against the defendant today for herself and her daughter, and she's looking to get one for her grandma as well. Ms. Kaya also let us know, which is disturbing to the state, is that when the defendant was going away to jail, he stated that when he gets out, he's going to kill her. He's going to kill her daughter and her grandma, Your Honor. And so Ms. Kaya also let us know that she and her grandma are terrified of the defendant and that they do not want any contact with the defendant, and they also want him to stay away from their address, Your Honor. She also, additionally, she let us know that she sustained back and neck injuries from being slammed to the ground, that she was going to go to the hospital to get that checked. For these reasons, the state's recommendation is a $5,000 surety bond, 1-day anger awareness course, no further contact with Ms. Kaya Troutman or the grandmother, as well as no alcohol, drugs, or weapons while out on bond, and to stay away from 1240 Princess Avenue. Additionally, I would like to sound from Ms. Troutman if she's on, Ms. Kaya Troutman, if she's on the Zoom call. Judge Morrow, you're breaking up.
Ms. Troutman, if you're on the line.
Can you hear me?
Yes, is this Ms. Troutman?
Yes, this is, Your Honor. How are you?
I'm doing well, thank you, ma'am. Can you raise your right hand for me?
Yes, I can.
Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, ma'am. What would you like to tell the court?
Okay, so what happened on that day, I was actually going on a date with a guy named William. And before I left, I had asked my grandmother and my baby what would they like to eat. And so they told me Popeyes. As I was leaving, going down the stairs from my grandmother's house, my uncle were saying words to me that were very disturbing. We did have a back and forth, which was going on outside. I did also tell him that the keys that he had stolen from my grandmother's house, that I would like him to put the keys back. And if I got back and the keys were not there, that I was going to call 911. He had already told me that he was going to call the police, but he didn't end up calling them. So when I came back from the Popeyes, William brought me back, and I had asked my 6-year-old daughter to come to the door to my grandmother's home, which is the front door, because they share a front door together. Everybody in the building shares that front door together to keep other people out of the building. And as I asked my daughter if she could come downstairs and to open the door for me, he then states, "Bitch, she ain't opening up no motherfucking door." He then blocked my daughter, my 6-year-old daughter. Just give me 1 second, sir.
Okay, take your time, Ms. Troutman.
He then blocked my 6-year-old child from coming down the stairs. She was trying to come down the stairs. He then pushed my 6-year-old daughter down on the floor. She got back up, she says, and that she went under his arm to come downstairs. She came downstairs. He followed behind her. She then, when he followed behind her, I waved my friend down, which was Will, that was with me, to get out the car, because I knew that he was going to start some drama with me. I then placed the food down and my wallet down on the side of the porch. And by that time, my daughter had opened the door. She was crying. She was very upset. He then grabs me, pulls me inside of the door, closes the door, and he starts hitting on me, punching me, choking me. He then stated as he was choking me that he wanted to kill me. Then I ended up on the floor. My daughter ends up running upstairs to go get a knife, my 6-year-old daughter. There was a guy who also stays in the building, who is the not the property manager, who comes outside and sees that me and my uncle are tussling. And I felt like that he was in cahoots with my uncle, because he never stopped my uncle from hitting me. Will then came inside of the door and then grabbed my uncle by the belt and told my uncle to please get off of me. He then got off of me after punching me in my face profusely. He then gets up eventually, and I end up picking up my hair. And I guess he didn't know that I called the police. So after I picked up my hair, I then tried to go upstairs to my grandmother, my baby. I wanted to console my daughter as well. My baby was crying on the steps. And him and the property manager would not let me upstairs. And the property manager and him end up pulling on me and pushing me out the door, locking me out the door, saying that I could not come upstairs. I then was telling my daughter through the door, "Please get off the steps. Please go upstairs to your grandmother. I'm okay. Everything is going to be okay." And then the police came and my uncle ended up getting locked up. I also have the person that I was with, which was William. He's also here to also witness the situation. My uncle pulled out my hair. I do have injury to my neck, where my neck is stiff. I cannot move my neck right now at this moment. I did want to be here today, so before I go into the hospital, because I wasn't sure if I was going to have service in there or not. My arm hurts. He also had his knee in my back, so I'm going to go get my back checked today as well. My grandmother would like a TPO out. She wants me to go down there. My grandmother is 85 years old. Okay. She cannot move. She cannot come down to the courthouse herself to do anything, to write or anything. She could barely write. She has arthritis in her hands. Honestly, my grandmother is afraid. He has been stealing my grandmother's things out of her home. He has been calling her bitches and hoes. He has been telling
Okay,
me that.
thank you, Ms. Troutman. I think that the court gets the picture, okay? All right, thank you, ma'am. Any questions, Ms. Bickerstaff?
No, Your Honor.
Okay, we appreciate you being here, Ms. Troutman. Ms. Kim?
Yes, Your Honor. Mr. John Troutman is 62 years old. He was born and raised here in Georgia. He's actually part-time mathematics teacher at Georgia Tech. He graduated from Georgia State University with master's degree, and he's not going to be qualified for public defender's services. Well, my client denies the allegations. That's all I can say. And we would like to request for signature on bond. If Your Honor is not inclined to give him a signature on bond, even though his last criminal background was from 1999, which is very remote, and there was no conviction whatsoever, we would like to request for maximum $1,000 bond. Thank you.
Yes, Ms. Troutman.
Excuse me, Your Honor. First, let me just state this. That was nothing but a lie. But would
Okay,
you like
hold on, Ms. Troutman. This is just a bond hearing, okay? You're gonna have the opportunity to address a court down the road with regards to all of the things that you've told the court today. So it's my job to listen to both sides and to make a determination. And this is just on the bond and what the state has asked for the court to do and what Ms. Kim is asking for the court to do, okay? So you're gonna have the ability at probably multiple phases of this to tell your story and to have any other witnesses or things of that nature that you want to testify. So yes, ma'am.
Oh no, you answered my question. So you would not like to speak to my witness today?
I think that you've enlightened the court enough for me to make that decision, okay? All right, thank you, ma'am. Is nothing further. It's going to be a $3,000 surety bond. No further contact with Ms. Troutman. Stay away from the 1240 Princess Avenue address. No drugs, alcohol, or weapons while out on bond.
Your Honor,
okay.
Excuse me.
One-time law enforcement officer escorted visits to
It was my understanding that they didn't live together.
But he resides at apartment number 4, and then they reside across from his apartment, I guess.
In apartment number 3.
That's all I wanted clarification. This is apartment building, Judge. It's like maybe about 4 or 5 apartments in one building with one main entrance in there. So I guess he lives in the building or whatever in one of the apartments, like she indicated, 3 or 4. I don't know what the number is, but
4. He lives
in 5
apartments.
I'm going to keep him from having any contact with Ms. Kaya Troutman. So no contact means no contact. So he cannot go to, and if he's Mr. John Troutman, if you see Miss Kaya Troutman, you to have no contact and you to go the other way, no contact whatsoever. I'm not going to keep him out of his apartment, but he can't go to her apartment or to the grandmother's apartment, which is my understanding is one and the same. Okay.
Yes, sir.
Are we clear, everyone? Okay. Good luck to all of you. Thank you, Ms. Troutman.
Judge Morrow, for position number 11, the total bond was 5,000 SOB through pretrial, correct?
Yes, that's correct.
Thank you. And then we're completed here in courtroom 2.
Okay, tell me about position number 7.
Oh, position number 7. Okay, they bonded out.
Okay, and tell me about position number 10.
He's right here in courtroom 3.
Oh, okay, he's in courtroom 3, and I think that will be our last person. All right.
It's a she.
Okay, that she will be our last person. Thank you. We appreciate it, Francois. We'll see you tomorrow.
Okay, see you tomorrow. Thank you, Judge.
Okay, thank you. Good afternoon, Ms. Hutchinson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Courtroom 3, you're on. Okay, go ahead. Ms. Hutchinson,
Yes.
did you hear me?
I can't hardly hear you. He just hit the thing.
Oh,
Yes,
okay,
sir.
we're doing this by video. Is that okay with you?
Yes, sir.
All right, thank you. Ms. Hutchinson, you've been charged in case 23 CR 003576F with 3 interference with custody counts. Is there a history?
She has 2 cycles. The defendant's last arrest was July the 8th, 2022 for simple battery, and that was in Fulton County. There was no disposition for that arrest, Your Honor. The defendant does appear to meet the criteria for UJR due pretrial services. Nothing in addition, Your Honor.
Ms. Falk?
Yes, Your Honor, this happened. So kind of beginning from the start, Miss Brichana McDaniel involved in this case. She stated she had seen her children June 1st at 3 p.m. when they helped her with trees and then went to play in the park. She then could not locate them in the park that afternoon, and it went into evening. She did contact the police, and the 3 children that were missing were AP 14, JM 6, and AP male 10. The officers kind of did a full dispatch, being there were 3 children. They were able to look at the camera unit and see the children walking on Perry Boulevard with 2 teenage males to the Circle K at around 4:30 p.m. The officers were then provided additional information to go to the residence at 1595 Mary George Avenue Northwest. They went to that residence. They spoke to a juvenile who answered. The officers asked to speak with the mother of the juvenile, who's the defendant, who yelled at the juvenile to shut the door while the officers were trying to provide the reason they were there. JH, who is the juvenile who opened the door, continued to talk to officers and ID'd the 2 boys in that footage that was captured from the poll camera as his brother. Came down, the officer spoke to the brothers. They denied that the 3 juveniles were in their home, but their statements regarding where the juveniles went were very conflicting. So at that point, the officers asked if they could go into the home and see if the 3 juveniles, AP, JM, and AP were there. They were allowed in, and they found the 3 children in one of the bedrooms. At that point, the children were taken back to their mother. When the officers tried to continue a conversation or reinitiate a conversation with the defendant about the missing children she was harboring, she refused to speak to them at all. We did have a chance to speak with Miss McDaniel and would like to sound for her, although she said she wasn't going to be able to be here on the Zoom this morning, but she did speak with our victim advocate, and she stated that she does not know this defendant. She stated her daughter, Amaya, stated she has a friend who lives at this residence, and she stated that when they were trying to inquire if the children were in the home, the defendant would not come to the door, and stated she doesn't have anything to do with it. She said her children are safe and are unharmed, and that is the conclusion of Ms. McDaniel's statement. The bond was currently set at $15,000 surety bond, $5,000 for each child. We are agreeable to reducing it to $2,500 per child and per count, which would be a $7,500 surety bond. No further contact with AP, JM, or AP. No alcohol, drugs, or weapons, and also stay away from 2265 Perry Boulevard Northwest, which is where the 3 children live with their mother, Miss McDaniel. We're also asking for no further contact with Miss McDaniel. I know she is she was not present during this. However, because she is the custodian, the legal custodian and mother of the children, we'd ask for a stay away from her as well. That's all for the state.
Ms. Falk, I'm sorry, you're gonna have to, I'm a bit confused. And so Ms. Hutchinson has no connection with either of any of these children?
Miss McDaniel doesn't know them. The only thing that she stated was her child, AP, the female, 14,
Okay.
stated she knows one of the juveniles at the defendant's home. That's it.
Okay, so they were found in Ms. Hutchinson's home.
That is
And
correct.
who went to check on them, or?
So the officers wanted to speak with Miss Hutchinson, the defendant, but she refused to speak to them, told her child to close the door on them, but they continued a conversation with the child, which led them to find the children in an upstairs bedroom.
And how were the officers alerted that there was an issue with the children?
That there was an issue with it? Well, the children were missing. So Miss McDaniel, the mother, called the police when her 3 children were missing for over, it was close to, I think, over 24 hours by the time they located
Oh,
the
okay,
children.
okay.
Yeah, so the
I'm
children
sorry,
had been missing for about 24 hours when they found them.
Okay, I understand. Thank you.
Yeah.
Yes, Ms. Wills. Hold on, I'm sorry, Ms. Wills. Is Ms. McDaniels present? If you are, then now is your opportunity to address the court.
Yes, I'm here.
Okay, can you activate your camera
Yes,
for
sir.
me, Ms. McDaniel?
Yes, sir.
All right, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down, ma'am. What would you like to tell the court?
I would just like to say, as what the lady said, we did go to the home. My daughter, she told me, she showed us where she lived. We just went around there to like have a conversation about what happened. A juvenile child, she came to the door. We asked her where her mom was. She said her mom was upstairs. So we asked her to go and get her mom, but she slammed the door. So she comes back with a juvenile young man. He's like, yeah, we want to speak to your mom. So they proceed to say what she said, that her mom says she don't have anything to do with it and she's not coming to the door. So we were getting ready to leave. There were some more children that proceeded to come to the door yelling and all that stuff. Like, we didn't come there for that. Then the mama finally showed up at the door. She was naked with a sheet wrapped around her. We trying to talk to her and she proceeds to say the same thing. She don't have anything to do with it. My thing was, you were the adult in this situation. It would have been adult of you for you to at least call, get the number from my daughter to call, because she knew our number, or at least attempt to ask, like, where do you kids live? You have 3 children in your home that didn't live there. I was worried sick about them. Like, I didn't know where they went. And I just didn't understand that situation, but I'm just glad that they're okay, and that's it.
Okay, so you've got a 14-year-old, and the 14-year-old was gone for 24 hours, and
My 14-year-old, yes, Amaya Patterson. When I got home, it was like 2:50 maybe. They helped me with my groceries out my car because they was already outside on the porch when I arrived home.
well, if they were gone for 24 hours, why didn't your 14-year-old call you to let you know where she was? I mean, have you talked to her about that?
Yes, I talked to her about that. She said that she was scared because it got dark after hours. So where they was, it was quite of a walk from there to our home. She stated that she was scared to walk back home and thought she was going to get in trouble. But I asked her, like, why didn't you call us? She proceeded to say that she didn't know our phone number, but she definitely knows my phone number and my mom's phone number. She knows our number. So I didn't really understand why she didn't call. Like, when they came home, they was dirty, like they was playing in the dirt or something, or they was, I don't know. It was just, wasn't nobody really saying anything. She just said that she was there with a friend. Which friend? I don't know. I don't know if it was a girl that came to the door or a young lady they were saying that was pregnant. I never saw that young lady because she never came to the door. But the younger children said that they was there playing tag and stuff, and that they was hungry and stuff like that. But other than that, that was really it. When I saw them, they went to the playground. I watched them go to the playground. That was around 3:00. And then like around about 5, I went back around there like to see were they still there because I was cooking them food to let them know not to go anywhere, but they was already gone at that time. So
And
I
who did they go with?
it was my 14-year-old, my 10-year-old, and my 6-year-old. The playground is connected to my apartment. So they didn't go far. The playground's not that far. I live 2 buildings away from the playground.
Once they left the playground to go apparently to Miss Hutchinson's house, who did they go to Miss Hutchinson's house with?
I'm guessing they went to Miss Hutchinson's house with the 2 boys. It was one boy that was walking with them, and there was another young man that was on a bike. I'm guessing they went with those 2 young men. I don't know the 2 young men. I'm thinking that there are 2 young men that my daughter, my 14-year-old, went to school with. She just graduated from John Lewis. So I'm guessing they go to the same school. I never met those kids. And the other kids she had played with, I have met them because they have came to my door, knocked on my door and stuff like that, introduced themselves and stuff like that. But those kids, I don't know those kids. And my daughter, when we move places, she meets new people and stuff. So I don't really know them.
Okay, thank you, Ms. McDaniel. Ms. Falk?
Thank you.
I think I can fill in the blanks on that one. So the warrant said when they did the full scale search, they canvassed the apartments, next door. They found a camera on the street had picked up her 3 juveniles walking with 2 male juveniles down the street to the Circle K and then down the street and out of view of the cameras. Those
yes,
2 juveniles.
Sorry.
No,
they normally go to the library. I'm sorry. They normally go to the library that's down there by the Circle K. That's right there on the corner at the light. They normally, my 10-year-old and my 14-year-old, they normally go to that library and read books and stuff. They normally go there and do that.
So Judge Morrow, those 2 juvenile males were the 2 in the house that were identified by the officers and by another juvenile in the house as the 2 young men who are walking with Miss McDaniel's 3 children.
And are they all about the same age or?
Let me go back to the warrant and check. It was unclear to me whether they were all around the same age or not.
Yes, if I could.
Okay, yeah, we'll get, I understand, Ms. Wills, you want to jump in here also, and I see Ms. Hutchinson back there. Ms. Hutchinson, let Ms. Wills speak on your behalf, okay? I see that you're animated, but give her the opportunity to let me know what's going on. Go ahead, Ms. Wills.
Your Honor, this is just a gross mischaracterization of a statement of facts. My client has nothing to do with what happened. This situation is amongst unruly teenagers who were at some place that they should not have been at, and then were too scared to return home once they recognized the trouble and just the severity of the situation. My client is a mother of 10 children, 9 of which are in the home. They range from 17 all the way down. So she does have children that match up and align with the same ages of Miss McDaniel's children. My client works at the airport. She works from she has gone from 11 a.m. through 12 a.m. every night with her transportation and working and getting back using public transportation. She said she was off work. She went home. She sleeps. Based on what Ms. McDaniel stated, her 14-year-old had her phone number, could have called, knew she should have called, and was definitely old enough to be responsible for her 10-year-old and 6-year-old siblings. They all went over to that home together, unbeknownst to my client. Again, she has 9 children. So she was not aware that there were 3 additional children that were in her home. She had no knowledge of this incident. So for all of those reasons, I would request a signature on bond. Hopefully this charge can be dismissed down the road. And if Your Honor is not so inclined, well, actually, I would ask that you follow the pretrial's recommendation of the UJR. In this case, my client has very minimal history.
Your Honor, one of the juveniles, EH, is 16 years of age.
Okay, thank you. This all sounds a little odd to me, to be quite honest, on both sides of the aisle here. So it's going to be a $1,000 signature bond through pretrial per charge, makes it for a total of a $3,000 signature bond through pretrial. Ms. Hutchinson to have no further contact with the minor children or Ms. McDaniel, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Ms. Hutchinson. Okay, I think that concludes the calendar today. So Let's see, Ms. Lewis, whenever you are ready.
Okay. The reset that date for the SAP is going to be June the 20th. Position number 1 received a $2,000 surety bond reset for SAP. Position number 2 was a $1,000 SOB through the jail reset further notice. Position number 3 was a total of $1,000 surety bond reset for SAP. Position number 4 was a $3,000 surety bond reset for SAP. Position number 5 was a total of a $4,000 SOB through the jail reset further notice. Position number 6 was a plea. Position number 7, defendant was released on the bond, reset further notice. Position number 8 was a $3,000 SOB through the jail, reset further notice. Position number 9 was a plea. Position number 10 was a total of a $3,000 SOB through pretrial, reset further notice. Position number 11 was a total of a $5,000 SOB through pretrial per judge, reset further notice. Position number 12 is a $2,000 SOB through the jail, reset further notice. Position number 13 is reset for tomorrow SCA counter for June the 6th. Position number 14 was a total of $5,000 signature bond through the jail, reset further notice. Position number 15 was a total of a $2,000 SOB through pretrial per the judge. Position number 16 was a $3,000 SOB through pretrial per judge. Position number 17 was a $5,000 surety bond reset for SAP. Position number 18 was a $3,000 SOB through the jail, reset further notice. Position number 19 was a plea. Position number 20 is a $1,500 surety bond, reset for SAP. Position 21 is a $1,000 surety bond, reset for SAP. Position number 22 is a $3,000 SOB through the jail, reset further notice. Position number 23 is a $2,000 SOB through the jail, reset further notice. Position 24 is a $3,000 surety bond, reset for SAP. Position 25 is a total of a $3,000 SOB through pretrial per judge, reset further notice. Any questions or corrections or concerns?
If not, thank you all. You all have a good rest of your afternoon. And Ms. Lewis, as soon as you get me the paperwork, I'll get it back to you, okay?
Thank you,
Thank you, Judge.
All right, y'all have a good afternoon. See you tomorrow.
All right, bye-bye.